Hi, Ed.
Morning.
Hi, Ed. Hey, Ed. Do you have everything
Hi,
you
Megan.
need in terms of script and all that stuff?
What did you say? Do I have everything I need? Yes. I mean, got
Yeah,
all the
okay.
materials. Yeah.
Lovely.
Yep.
Great.
problem.
How's Canada?
Oh, it's beautiful.
Yeah.
Lovely. A little bit hazy this morning, but about 56.
Well, I'm coming up there, Ed. I'm ditching Maine. It's going to be 85 degrees here today.
It'll go up to 65 later
Oh my
this
God.
afternoon.
Heat wave.
Heat wave.
Okay, I'm going to go let the masses in. We'll come in.
So Mark and Tom are not with us?
I'm
person?
expecting Mark, but Tom is doing college visits, so he will not be here.
That's not possible.
Oh,
They're not our time. I have to.
Oh, perfect. When I present, I just had a quick question.
Oh, that's okay. We'll get to you when.
Okay, okay. Okay, thank you.
Something I noticed. I used the wrong template. She's not back. I know. It's like, sometimes I wouldn't object. Yeah. She decided to come back. Right. That's just. I'm still finding that all over the place. And I just don't know the more.
I do the same thing. I talked to her yesterday, she's not good.
Okay.
How is she? She's good.
And do you mind if I sign your voucher for you?
no, please do. Absolutely.
Good morning.
Hi, Mark.
Thank you.
Hi, Mark.
Morning.
Hi.
Not too bad.
To be seen how well.
Yeah,
It's popping, yeah.
yeah. Well, if you're, what, is it this weekend? Is awful.
No, it's not even this coming Saturday, 2 weeks.
Oh.
It's usually the third Saturday.
They have,
We went to it last year. It was a lot of fun. And then we went up to the international
Oh, yeah.
fair. I think that's been the New Rangers project.
Yes, that Blue Manus project can do a lot of good.
They do, yeah.
A lot of good.
That's what you have to do for your, then you get rich.
Yeah, that's my 3 miles, just like you.
Yeah. I know you two, your mileage is exactly the same.
how was your husband's dramatic reading on the 4th? Actually, it was not bad this year. Well, he practices.
You had the declaration?
Yes.
I'm involved with that. When I was mayor of Hollowell, that was one of my.
Well, this time it was inside the fort.
Trying to get into the drama.
Oh,
It's-
I always tell you so.
Oh, yeah.
Oh,
Oh,
yeah.
he's great, yeah.
Oh, yeah, oh, yeah.
Fantastic.
Yeah.
I-
Yeah.
Governor's inauguration
Uh-huh.
back in
Kit, would you remind me again, the folder that says IC's archival, those are the cases that are on the consent agenda? They're investigator.
I think so, but there is also a folder for the consent agenda. I don't know why that's in there. I think we will maybe just start taking it out because you don't need to look at it.
Well, I mean, I think I would like to see the ability to see some of the cases that are on the consent agenda, especially when they're
Isn't there a
reasonable
folder for
grounds
the
cases.
consent agenda in the drive?
Yes. I think the archival does not have the submissions with it. So
None of the
there
consent
is-
agenda cases. Oh, I see.
So that there is a
Gotcha.
list of all the
Yes.
cases
Okay.
as written.
Yeah, so what Barbara was saying is that the archival one has all of the reports, but not any of the submissions to disagreement.
Yeah, he's great.
But all of
Right,
that information
right.
is also in the hearing cases and the consent agenda folder.
Okay, can you access the cases in the consent agenda directly from the agenda? No, you can't.
From OneDrive,
Yeah,
if you're in.
yes, from OneDrive.
Yeah, do you see number 4, consent agenda?
Oh, I see. They're under consent agenda. Yes, I got it. Okay. All right, you ready?
Yep.
Okay. Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, et cetera, to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. Thank you. And with that, I think we will commence the business meeting. First item is adopting the agenda and the consent agenda, if there's a motion to that effect.
Julie?
Second.
It's been moved and seconded. Is there any discussion? Seeing none, our remote participation policy requires that the commissioners indicate their vote both visually and audibly. So I will ask you to raise your hand and signify your vote. If you vote yes, you are in agreement with the motion. Commissioner David.
Yes.
Commissioner O'Brien.
Yeah.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Okay. I had you all vote on the May minutes last time and I didn't give them to you. So let's vote on them for real this time. I realized that as I was doing the minutes for the last meeting. Okay, so do you want to take them both together, May and June, or would you rather do them separately? Together. Together? Okay. Julie, was that a motion?
Yes.
To adopt the minutes? Yes. Great, for May and June. Okay.
Second.
Thanks, Mark. It's been moved and seconded. Any discussion? Seeing none. Commissioner David.
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Thank you very much. Okay, reports from me. For personnel, I think we had not hired Jillian at the last meeting, so we have hired Jillian Payan, who is our new Secretary Associate Legal, to fill the position that Chelsea vacated. She's wonderful. She's catching on very quickly, which is great for the front office and also for the commission as a whole.
Wonderful.
Yes.
Congrats.
Yeah, and we are in the process, we have interviewed candidates for the investigator's position, and we are in the process of making an offer. So fingers crossed, we'll have news for you on that next month as well. For compliance, Jane wrote you a lovely memo, which I have right now. Yes, here we go. So we have 3 cases in active conciliation, 2 cases that failed conciliation, 2 cases with successful conciliation. We don't have agreements in those yet. We're still waiting on signatures, so I will give them to you at the next meeting. But we also have 2 memos from Jane to dismiss cases that have completed their agreements. She's done monitoring them. So I need your approval to dismiss PA 19-0346 and H 20-0531.
So moved.
Commissioner Sanders, a second?
Second.
All right, so if you vote yes, you are in agreement with that motion. Commissioner David,
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
All right, and pending cases. We had 39 new charges in June, 15 cases that were dismissed, 1 right to sue, 1 mediation settlement, 12 private settlements, and 1 withdrawal with no benefits. And I was saying at the beginning of the meeting that I would have the numbers for you on how much complainants got, except my computer is not cooperating with me today, so I can give that to you at the next meeting if you would like. I think that's pretty much it for the reports. We are coming up to the end of our HUD. No, we have ended, our HUD fiscal year ended last month, so if it's a little quieter time, it's because we were doing a lot of work to make sure that we had complied with their requirements on reporting. I did give you all a memo with the dates, proposed dates for next year's meetings. It is already time. I need to reserve this room ASAP. So I'm not totally sure that we need a motion for this, but let's do one anyway if those dates work for you all. Or if those dates work for a quorum of us. We don't grade based on it.
I move we adopt the proposed meeting schedule for 2025.
Great, thank you, Commissioner
Second.
David. Thank you, Commissioner Sanders. So if you vote yes, you are in agreement with that. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
and Commissioner Sanders.
Yes.
All right. Commissioner Douglas will be on his own for that one. I would ask that we take litigation in executive session. That's all for me. No new business. I will have new business for you in the next few months as we get into budget season, but we're not there yet, thank goodness, so I have a little breathing room. Any questions about any of that? I feel like I have had a lot of coffee and I may have run through it very quickly.
Very efficient.
Great, okay. Ed, would you like to put us in recess for 7 minutes?
Yes, we'll be in recess until 8:45, at which time we'll call the first case on the hearing agenda. Okay,
Stodgy former chief commissioner. Chair.
hold on just a sec.
Sure.
Okay, we'll call the meeting to order and we'll call the first case, which is E22-0183, Jane Whiteside versus First Atlantic Health Woodlawn Rehabilitation. The investigator is for a finding of no reasonable grounds on both counts, and therefore we'll hear from petitioner.
Stephanie, that's okay. Okay, am I able to sit down here?
Sure.
Okay, just wanted to know, just in case.
So Ms. Whiteside, you'll have 10 minutes. Did you want to reserve any of that time? The podium does not adjust.
Okay, can I just sit
Yep.
here? Okay, I know, yeah, I have to be on camera. Everybody all set?
Yep. Do you want to reserve any of your time?
I'm gonna give my presentation. I guess I reserve time if I have any extra. So,
Whenever you're ready.
and I have my information. My name is Jane Whiteside and I'm the complainant. It's against First Atlantic Healthcare Woodlawn Rehabilitation and Nursing Center in Skowhegan. And I have a truncated version of my disagreement with the investigator's report. And I'm just going to be focusing on what I feel are the main concerns, and it all comes from the report. So a summary of the case: the complaint resigned orally, asked the administrator respondent, this is Woodlawn Rehabilitation and Nursing Center, to find a replacement on June 30th, 2021. The complainant resigned in writing to the administrator respondent per 1 month per contract on October 29th, 2021. This was 2 days before a Department of Health and Human Services agency survey. That's what I refer to. In this presentation, the complainant will review previously submitted information to prove that the complainant was constructively discharged. Based on previously submitted information provided by the complainant, respondent, and the investigator, the complainant recommends that myself to the commission a finding that there are reasonable grounds to believe that the respondent retaliated against the complainant in violation of Maine Human Rights, MHRA, and the Whistleblowers Protection Act, with at least an even chance at trial of the complainant prevailing in a civil action. So the analysis of the case, what I find is the factual background and awareness of the legal case. The complainant participated in agency, that's DHHS, investigations of safety concerns regarding the respondent not following rules and regulations for Medicare participation. These included, among the complaints by myself, was a lack of qualified food service director. And this was followed up by the state after my tenure at the nursing home on March 13th to 16th, 2023. But especially at the time of the concern, there were many food safety complaints, was the broken dish machine. This was in the survey of October 25th to 27th, 2021, alleged by myself, and filed in my complaint to you on August 20th, not to you, to the DHHS, the agency, on August 20th, 2021.
Ms. Whiteside, I'm just gonna pause your time for just a minute. I realized I forgot to say at the beginning of the meeting to please not use the name of third parties or entities that aren't named named parties to the complaint. So when you're referring to the agency, if you could just say agency.
Okay, that's fine. Okay, I'll just say the agency. Okay. In filing a complaint with the agency, the complainant stated that confidentially was not desired. So the complainant was aware that the respondent would know as soon as possible from the agency about the complainant from the complainant. The agency has all of the personal notes, updates, reminders, and recommendations per consultant dietitian report since January 2021 that the commission has at this time. These allegations of non-compliance were substantiated by the agency. The complainant was a consultant dietitian. Was my position. And I'm also a certified food protection manager. And I have additional training, way above and beyond, certified food protection manager, instructor, and proctor. So I worked there for 12 hours per month, $30 per hour. Usually visit the facility, the respondent, 2 separate visits per month. And I had completed uncompensated work on menus at home for 5 hours, and as well as spent extra time on each of these visits beyond contract those 2 days. So I wasn't going extra days, but I was going a very full day there. I recommended, with all these procedures going on, I was trying to leave the position, but I recommended to the responded that the dietitian services should be 8 hours per week for the replacement consultant dietitian because of the COVID-19 in the overall environment. I notified the respondent through the dietitian reports verbally, as well as in writing, about alleged violation practices prior to filing a report with the agency. The respondent was provided prior notice, as I see it. If there is one thing that the commission should look at, it is the agency findings about the broken dish machine and the lack of qualified dietary staff, which shows that the defiant actions of the administrative respondent towards the agency's findings. The complainant reported all concerns and recommendations in consultant dietitian reports that the administrator responded. The agency had the findings because they had the evidence from the complaints. They already had all the evidence. So the complaint mainly focused on 2 things. The thing 3/16/2023, which I had also initially filed with the state earlier. The F tag was F0801, employ sufficient staff with the appropriate competencies, skills, and sets to carry out the functions of the food nutrition service, including a qualified dietitian. And what happened on the state reports to the facility on 3/13/2023, in an interview, the surveyor discussed the finding with the administrator. The surveyor asked the qualifications and dates of hire for the last 2 food nutrition directors. So that would be when I was working at the facility. I was already gone, but that would deal with my complaint. None were provided as of the end of the survey. And then on that, couple days later, after the surveyors left, the surveyor emailed the administrator with a request of dates of employment for the food service director and received an email from the administrator confirming the current food service director was hired on 4/5/2022 in the kitchen, but did not take over the food service director position until December 2022. The administrator confirmed that the current food service director does not have the qualifications of a certified food service director. And when I was at the facility, or by the time of the survey, 10/27/2021, there was an F tag, F0908, keep all essential equipment working safely. This had to do with the dish machine. On 10/26/2021, at 1:52 p.m. in an interview, the administrator dated that the dish machine had been leaking since she had arrived in January 2021. She went on to state that the dish machine had been leaking long before she came to the facility. She stated that it had looked at it in the past by a contractor, but had not been fixed. At this time, the administrator confirmed that the dish machine had leaked for many, many months and had not been fixed or replaced. And then the surveyors came the next day and looked to see what was going on with the dish machine. And on 10/27/2021, during a kitchen tour, a surveyor observed that the low temperature dish machine had 2 large buckets underneath it, each half full of dirty water. The surveyor also observed a large amount of water on the floor around it under the dish machine. There was a black mat on the floor for the staff to stand on, and when lifted by the surveyor, the water covered the floor under the mat. So I have looked at the case also, Sullivan versus St. Joseph's Rehab and Residence. I'm familiar with that. I didn't look into the other cases as much. As a complainant, I am now currently unemployed. The complainant consulted myself there for 20 years. administrator did not treat the complainant consultant dietitian as a valued member of the healthcare team, as the administrator reported it in her response, the respondent's response. I think it was on September 20th, 2022. So I believe there are reasonable grounds to believe that First Atlantic Healthcare and Nursing Center retaliated against myself in violation of the work WHA, and WPA. The complainant should be accepted in accordance with 5 MHRC 4612. Thank you for your time.
1 minute left when we come back to you. Any commissioner questions for Ms. Whiteside? Seeing none, you can sit back down and we'll close.
Okay,
Yes,
thank you.
no,
Oh, sorry, Commissioner David.
Yes, Ms. Whiteside, I think that you agree with the investigator that you did resign, and therefore what your obligation legally is to show a constructive discharge, and the standard for that is that the working conditions were made intolerable because of your complaints. Do you believe that that's the correct standard and that you've met that standard?
Oh, yes, I gave notice of all the, I gave notice of the dish machine in my reports. The other staff following up about the dish machine, they're waiting to order a dish machine, They couldn't purchase it themselves. Also in the reports.
I understand.
No, let me just.
I
finish.
understand.
Like Commissioner David finished.
Okay.
His question.
So, and I also.
Go ahead.
And I also gave information about having lack of staff. And I gave, so I believe there is a case. I would say the one thing that I didn't do is notify, we have the workplace poster. I didn't notify their compliance officer or their director of operations about my complaint to the facility, but I did the best I could in August 2021 to comply discuss all these concerns.
The question I'm asking is not about what you did. I'm asking about what you say the company did in retaliation in terms of your employment. What conditions did they change? Did they reduce salary? Did they reduce hours? I understand that you pointed these discrepancies out to them, and they may have been long-standing, and that's a normal. I mean, that happens all the time in healthcare facilities with reviews and evaluations, and they get gigged for one thing or another, and you have to improve it. But how did they retaliate against you in your view?
They retaliate. If I would go to an interview, I'd have to discuss this situation to other people, and it's very stressful to talk about this. So yeah, it's retaliation.
Thank you.
All set?
All set.
Thank you.
Right, and for Attorney Rand.
Good morning. I'm Katie Rand, and I represent First Atlantic and Woodlawn Rehabilitation and Nursing Center. And I'll be very brief. That final exchange with Ms. Whiteside, Commissioner David's question and Ms. Whiteside's response really actually crystallized what I see as the deficiency in her complaint. Ms. Whiteside is very focused on findings of noncompliance in her report to DHHS. And for purposes of this morning, we can concede that both of those things occurred. The problem is, well, twofold. She's offered no evidence that the facility was aware that she herself made the report to the agency. And then there's a problem of causation. Ms. Whiteside acknowledges that she initially resigned in June of 2021, which is several months before she filed the complaint with the agency. She does maintain that her periodic notes to the facility contain protected reports. I've reviewed those reports, and like the investigator, I do not see reports of violations of the law or conditions or practices that give rise to concerns about safety or health. Even if those were in those reports, however, Ms. Whiteside concedes that when she resigned, the administrator at the facility effectively begged her to remain on, which is not consistent with a theory of retaliation, and that she did in fact remain on, which is not consistent with a theory of constructive discharge. If a work environment is so intolerable that no reasonable person could be expected to continue to work in it, those are not the circumstances under which one agrees to work for an additional 6 months, 5 months, and are not the circumstances under which one later, within days of the agency coming in to do their survey, renews that resignation and offers to work a 1 month notice period. And so respectfully, the facility was not pleased to see Ms. Whiteside go. They needed her. And, you know, it's unfortunate that she didn't feel appreciated and that she felt she needed to move on. But the facility did not take any steps to try to force her out, much less in reaction to any protected reports that she made. I'll rest there. Happy to answer any questions.
Commissioner questions for Attorney Rand? Commissioner David?
Remain, and that she did remain, and I tend to agree that that doesn't argue for constructive discharge, but
Commissioner David?
the question that I had, yes?
You froze at the beginning, so we missed the first part of that question. Could you repeat it?
Oh, okay. Well, actually, it was preamble. It wasn't really the question. The question is, could it be the case that the unsafe dishwasher was itself an intolerable working condition for a dietitian who's trying to deal with food safety? I mean, I think it may be a stretch, but it is possible that could be a working condition that they're refusing to change, is it not? How do you react to that?
So the Whistleblower Protection Act, as you know, has several prongs, and one of the prongs, which Ms. Whiteside is not invoking, but I think this might be instructive in response to your question, involves an employee who refuses to take some act, right, who engages in insubordination almost, if you will. In that context, the complainant is required for that to be protected, to establish that the harm that would flow, and I'm sorry, I don't have the statute in front of me, but is quite significant. Death, for example, or significant bodily harm. Here, certainly that's not the case, but moreover, the agency came in and issued a citation of correction, or required the facility to create a plan of correction 2 days before Ms. Whiteside renewed her resignation. So if anything, that was the time when Ms. Whiteside could expect that condition to be addressed, and it would render her resignation at that time all the more unreasonable, or at least not a constructive discharge.
Thank you. All set.
Any other commissioner questions for Attorney Rand? We have about 7.5 minutes and we come back to you. Ms. Whiteside, you have 1 minute left if there's anything
thank you.
you'd like to add.
I was during the survey, the initial one in October 2021. The agency staff called me and told me they were at the facility. The administrator did not call me and say the state was at the facility. It was in relation to my complaint and also as part of a regular survey. And when so I had no notification about what was going on except from the state agency. And I only came back on the end of Friday, the 29th, because that was my regular visit time. So I couldn't resign immediately on the 27th. I wasn't even there during the survey, but they communicated to me that the state was there and they were looking into some of my complaints. So that's my answer to your question and my rebuttal. Thank you.
Any other commissioner questions for Ms. Whiteside? Thank you very much. Attorney Rand, you have about 7.5 minutes if there's anything else you'd like to add.
I don't have anything to add. Thank you. Still happy to answer questions, of course.
Any other commissioner questions for Attorney Rand? Seeing none, we've heard from the parties, and next we'll hear from the investigator, Alex Brindley.
Good morning, everyone. My name is Alex Brindley. So very quickly, I think the facts outlined here, they're in my report, but I'm just going to summarize it up quickly. Complainant did not report alleged illegal and or unsafe conduct to the respondent. She indicated that she did so in her daily reports to her daily notes to her employer. I disagree with that. I reviewed all hundreds of pages of the notes that she provided to the respondent as a result of her daily work, and she did not report any non-compliance in those notes. So that's the first one. Second, as she, herself indicated, she wasn't subjected to any adverse action as a result of her report to respond to the agency. In fact, respondent was not made aware that complainant had made the report to agency in the first place. Complainant simply resigned before, anything retaliatory could happen. And that's it. I'm open to any questions.
Commissioner questions for Investigator Brindley? None. Thank you, Alex. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 2 proposed findings. Commissioner David.
I'll make a motion. I'll make a motion and to take them together and move that we find that there are no reasonable grounds to believe that respondent retaliated, and that there are no reasonable grounds to believe that responded retaliated in violation of WPA or retaliated in violation of MHRA, both of them.
So moved. Do I have a second?
Second.
Commissioner Walker. Right. So moved and seconded. Is there any discussion?
I just don't think there's any employment action that's retaliatory, that there's any employment action at all. I think it's fine to give her the benefit of the doubt that even her notes are the reports, but there's still no retaliation that affects her employment and that meets that definition of intolerable working conditions to meet the standard for constructive discharge.
Any other discussion? Seeing none, if you vote yes, you are in favor of the motion. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
So the findings are no reasonable grounds. The commission will send a letter to the parties confirming the results of the hearing. Thank you all for your participation.
The second case on the agenda is Amy Newell on behalf of minor child versus MSAD number 49. It's ED 22-0246. The recommendation by the investigator is for a finding of no reasonable grounds. Therefore, we will hear from the complainant first.
Cool. 10 minutes. Would you like to reserve any of your time?
I should have a minute or 2.
I'll start you off with 8. When you're ready, go ahead.
My name is Amy Newell, and in August of 2022, I submitted a claim of discrimination on behalf of my minor child who uses they, them pronouns against their school district MSAD 49 in Fairfield. Before an issues and resolutions meeting in May 2023, I added retaliation to the claim. The MSAD 49 administration is liable for the continuation of a hostile environment at Lawrence High School and the discrimination against my child because of this environment. The administration knew about numerous incidents of harassment through both student and teacher reports, but refused to consistently investigate, address, or even discuss the harassment in a meaningful manner. Specifically, my child was ignored until a slur was directed at them. An investigation was started only after I contacted the affirmative action officer. In the investigator's report, she states that my submissions accurately described the school's hostile environment, if they were to accurately describe the school's hostile environment. The harassment that my child experienced could be considered pervasive. Both my submissions and the witness statement described such an environment in detail. There are at least 38 incidents of harassment described in the witness statement, including incidents that were not investigated by school administrators and instances of harassment involving the same offending students in multiple cases. For example, the administrators were aware that student offenders from the March 23rd and April 14th, 2022 incidents involving my child had previously been part of reported cases of harassment, including an incident reported December 14th, 2021 that included graphic, detailed threats to kill another student who they had sexually harassed. Student offenders were allowed to continue their harassing behaviors. My written submissions also provided evidence of discrimination. Incidents when my child reported concerns about the hostile environment and no investigations occurred. When the admin treated my child dismissively and in favor of the offending students, and when other students reported harassment of my child and no follow-up occurred. One example of uninvestigated harassment, specifically regarding my child, occurred on June 8th, 2022, when another student reported my child had been assaulted by students who grabbed their pride flag off of them. My child's teacher wrote to their guidance counselor on June 9th, the day after, that other students were reporting my child had expressed suicidal thoughts the previous night related to the ongoing harassment and assaults they were facing at school. This incident, excuse me, was only one of many harassment incidents occurring in June 2022 related to Pride Month. The harassers targeted minority queer students to the point of desperation. My child expressed quitting the civil rights group so that if they had to physically defend themselves against the harassers, they wouldn't be representing the group. The school district has not provided evidence of an investigation into the June 8th incident. In fact, they only referenced an investigation report for June 3rd, 2022 regarding another student in their submissions when there were many more incidents reported. The timeline of uninvestigated harassment before and after the March 23rd and April 14th incidents shows the inconsistency and failure on the part of school administrators to investigate reports of harassment about which they had knowledge. This inconsistency directly impacted the continuing hostility in the school, which led to multiple harassment incidents against my child and created an environment in which my child felt unsafe. MS 8049 failed to protect and support my child and is liable for the discrimination they faced. The March 10th, 2022 meeting is an example of how my child was trying to report threatening and harassing behaviors from repeat offenders contributing to the hostile environment. The incidents that were reported to the admin in this meeting were also not investigated. In this meeting, the same administrator who claims to make their office welcoming forced my child to use their legal name instead of their known preferred name and forced them to say a derogatory term to clarify an incident that was never investigated. My child left that meeting feeling defeated and ignored by the authority figure that was supposed to support them. Regarding the March 23rd, 2022 incident of harassment that my child experienced, during which they were called a derogatory slur. An administrator first refused my child's request to have their teacher present at an in-person meeting to report the harassment on the day of the occurrence. My child did not want to go to the admin alone due to previous uncomfortable interactions on March 10th and had to delay reporting the incident because of this refusal. School staff were well aware of my child's mental health issues due to ongoing threats and harassment and it should have been a priority for admin to support my child's minor request. The district was not following policy. The stated staff should have reported the harassment to the affirmative action officer. This demonstrates discrimination toward my child for failure to follow their own policies and procedures regarding harassment. During a phone call I had with the assistant principal about the incident, he continued to use the wrong pronouns when referring to my child even after I corrected him. That he had been made aware of the correct name and pronouns by my child's teacher beforehand. This is gender-based discrimination. Regarding the April 14th, 2022 incident in which my child overheard a derogatory slur being used by another student in the hallway. In a follow-up meeting with my child about the investigation findings of this incident, the school administrator told my child that the offensive word was used between two students in conversation and that he had reviewed security footage without audio. He stated, "It didn't look like anything was said. No one else responded to it. My child reported it because they were present and it bothered them." The administrator then stated that it was just boys being boys and a maturity issue. If my child waited a few years, these students would stop behaving this way. The school administrator who completed this investigation repeatedly treated my child in a dismissive manner, demonstrating bias and intolerance to my child for reporting the incident. This was retaliation directed at my child for trying to report on the school's hostile environment. The admin may not have directly said the words "stop coming to me about these issues," but did so indirectly with their callous attitudes. My child's grades and mental health suffered because of the ongoing threats and discrimination they faced. My child missed out on normal teenage school-based activities.
Sorry, that was your 8 minutes. I tried to stop it before it went off. Obviously, I didn't manage. You have 2 minutes, I'll keep. Okay. My child missed out on normal teenage school-based activities and the chance to thrive in leadership positions because of the lack of administrative support for minority students at Lawrence High School. All of what I have reported speaks to the perpetual institutional discrimination at MSAD 49 caused by the administrator's implicit biases on the basis of my child's gender identity and the retaliation my child experienced when trying to report hostility. The on-paper policy changes and newly implemented trainings that the district started in response to my claims should have been in place years ago. Whether or not the school is now making efforts to change the hostile environment does not negate the fact that my child was discriminated and retaliated against based on their gender identity previously. The repeated harassment by the same students due to the lack of investigation, meaningful intervention or consequences, and the constant threats overheard by my child directly impacted their ability to learn and discriminated against their right to access a safe education. MSAD 49 is liable for this discrimination. Any commissioner questions for Ms. Newell? Seeing none, you'll have about 45 seconds when we come back to you. Attorney Felmley?
Yes, good morning. Can everybody hear me?
Yes.
Great, wonderful. Well, good morning and thank you for hearing the facts of this matter. I'm Peter Felmley, counsel for the school unit. Joining me this morning is Sean Boynton, also by Zoom. He's the assistant superintendent of the school system as well as the Title IX coordinator. And we appreciate the opportunity to address the facts of the case. The investigator correctly concluded that the evidence submitted in this case could not support a finding of discrimination or retaliation against complainant or her child. The investigator carefully considered hundreds of pages of evidence and the testimony of 6 witnesses and considered their credibility. The evidence very clearly establishes and supports the investigator's findings and conclusions, and the district respectfully requests that you affirm their findings and dismiss the complaint with a clear finding there's no reasonable grounds for discrimination or retaliation. With respect to retaliation, the investigator correctly noted there's absolutely no evidence that the district took any adverse action against the student, no discipline, no reprimand, no other adverse action. In fact, the district listened to their concerns, investigated allegations that were brought to them, and the district took steps to ensure that the learning environment was safe, supportive, and welcoming for all. The student has been encouraged to share their concerns so that the concerns could be investigated and addressed. The fact that they shared their concerns helped the district to understand their experience and allow the district to tailor its response to eliminate the problem and inappropriate behavior. With respect to the discrimination claim, the investigator also correctly found that the district could not be liable for discrimination or allowing a hostile environment to persist. The evidence established that the district and its administrators took seriously the acts of alleged discrimination brought to its attention and took appropriate, indeed commendable, responsive action to address the behavior that was substantiated. The district's foundational mission is to create a safe and welcoming environment where every student can learn. The conduct policies that were introduced to evidence drive home this point, and those were attached to the district's response submitted to the investigator, exhibits B, C, D, E, and F. Contrary to Ms. Newell's argument, these are not just words on a piece of paper. They matter to the school board, to the superintendent, to the Title IX coordinator, Mr. Boynton, and all school leaders. There is no dispute that complainant's child raised several concerns about conduct that was occurring and that all parties agree has no place in a public school system. Yet with respect to each allegation brought to the district's attention, the district spent considerable time during this proceeding detailing the prompt action that was taken to investigate the concern and take appropriate action. We're simply not able to review every single responsive action taken. Those were detailed and categorized in the initial response, but also its final submission. And I refer you to those materials, the district's October 28, 2002 response and the June 14, 23 submission for a detailed account of the actions taken. Mr. Boynton's witness statement, which was pages 4 and 5 of Exhibit A to the June 2023 submission, is really telling. He walks through each of the steps taken with regard to the concerns that were shared with the district. And if you haven't read that statement, I encourage you to do so. The steps taken were prompt, thoughtful, sincere, and as he specifically noted in his statement, they were effective. They worked to help the students involved understand that their behavior was wrong. On an individual level, the concerns raised by complainant's child were fully investigated. The district supplied summaries of investigation steps, redacted investigation reports, emails confirming actions taken, and statements by multiple administrators laying out the steps that they took. Contrary to complainant's suggestion that no consequences were ever imposed on any offending students, the district supplied information, including redacted student records, conclusively establishing otherwise. Discipline was imposed, education was offered. Also on an individual level, the district's information system was improved to permit the use of the students' preferred identifiers. Where there was appropriate action, inappropriate behavior found, again, disciplinary action was taken, education offered, and supportive measures were offered to the victims in each case. In addition to the individual actions, the district took laudable concrete steps on a systemic level to ensure that students felt comfortable in the learning environment, that staff were aware of what they should do when information was brought to their attention, and that the school system was safe. The district implemented staff training for administrators and teachers, both online and in person. Brandon Baldwin of the Maine's Department of Ed's Civil Rights Team project was brought in. Legal counsel provided Title IX trainings. The local area Forks organization, FORQS, which is Folks Organizing Reform for Queer Spaces, offered a staff training. Dr. Brown, the former dean of students, offered a training on the importance of inclusion and avoiding implicit bias. The school board established a DEI committee, the standing committee to help shape the district's annual priorities. Each individual school in the district created a DEI committee, and they pushed out student climate surveys to implement and fully understand what the students were experiencing. The district provides its handbooks for students to drive home the core expectation that preferred pronouns were to be honored. A Gay Straight Alliance Club was created to ensure that even marginalized students have a dedicated community where they can be themselves. The high school created a school-wide assembly and enabled the civil rights team to take over that assembly to help spread a message of inclusion throughout the school. Pride flags were installed at multiple central locations on campus, conveying a very firm and emphatic message of welcoming to all students. These steps reveal a school system and school board administration that cares deeply about its mission of creating a safe and welcoming environment for all students. These are well-documented actions and laudable actions, and simply do not support a finding of deliberate indifference or failure to respond to any inappropriate behavior. Before closing, I want to briefly address a couple of comments made by complainant. First, she referenced a newspaper story that allegedly includes some statements by some students. Newspaper stories are not evidence. The district provided evidence that amply proves that it took prompt, effective action when it was alerted to appropriate behavior. The district was not able to provide such evidence to the paper due to confidentiality concerns, and thus the story that was published did not include all material information. Complainant also relies heavily on the account of one individual, a former employee, who suggested that the school did not take certain actions that it did in fact take. The complainant's case relies to a tremendous degree upon the account of this former employee. However, the individual lacked firsthand information needed to render their account reliable. They were not present during the investigations conducted. That doesn't mean that the investigations that actually took place didn't take place. Again, Mr. Boynton carefully recounted the investigations conducted by the school system. The former employee did not know of the disciplinary consequences imposed because that person did not have a legal right to know and access that information under the Family Educational Rights and Privacy Act. That doesn't mean the action was not taken. The individual also claimed that no in-person teacher trainings ever occurred. The district supplied undeniable proof of the in-person training and written proof that the individual actually attended because their name was signed on the sign-in sheet. The district's position in this case was supported by fact, by multiple witness statements submitted by the administrator and reliable witness testimony. In closing, SAD 49 sincerely cares about its students and has worked hard to create an environment that is safe, supportive, and affirming for all students and their staff. It generally appreciates complainants' efforts and those of her child to raise awareness of critical issues. Their doing so has enabled the district to learn about the concern and take a thoughtful, multi-pronged approach to preventing and eliminating inappropriate behavior on campus. The district respectfully requests that you find no discrimination or retaliation occurred in this case. Thank you.
Questions for Attorney Felmy? None. You'll have about a minute left when we come back to you. Ms. Newell, you have 46 seconds. Would you like to add anything?
So I would just like to say there are incidents in my reports that the school did not provide investigations for. The March 10th meeting my child went to and the June 8th occurrence where my child reported their harassment. Secondly, all of the trainings and efforts that he reported started after I appeared at a school board meeting in June of 2022 to bring up these concerns. And when I started my complaint, those things didn't happen until I came to the school. Thirdly, I would like to say some of the information that he presented about the student portal didn't occur until after the dates of the ending for submission of information. So I'm not sure if I'm allowed to speak on that or not, but he mentioned it and that didn't happen until after the dates.
Any questions for Ms. Newell? Thank you very much. Attorney Felmy, you have 59 seconds if there's anything else you'd like to add.
There is nothing else that I would like to add. Thank you very much.
Okay. We've heard from the parties and next we'll hear from Investigator Morse.
Hello, my name is Angela Morse. I was the investigator assigned to this case. The amount of information that was submitted for this case was quite voluminous, and 6 witnesses were interviewed for my investigation, and after reviewing all the information and the testimony given, I couldn't conclude that complainant established that respondent was liable. It seemed like the respondent did take appropriate actions to address the concerns of complainant and other in the school community.
Angela, any questions for the investigator? Commissioner Sanders.
Good morning. Just a couple of quick questions.
Sure.
The report itself identifies 2 incidents that the complainant alleges happened that the school district investigated and then remediated. But it also appears that in April of 2022, the student and members of the civil rights team also met with school administrators to talk about a pattern, right, of bullying and harassment that certain students were experiencing. I'm curious about those incidents and whether or not you investigated those concerns in the context of this complaint.
I did. So there was the March 10th meeting with the civil rights team and one of the faculty members, where the civil rights team members expressed their concerns. And those, the incidents that precipitated that meeting were discussed in my report, such as the inadvertently turning up the speaker to the music when students had addressed their concerns. And then there was another meeting, or let's see if it was a meeting. There was a lot of dates in here, so I'm just trying to keep them all straight. There was an April 14th. Let's see here, I'm just gonna review this.
Yeah, it looks like on page 2, third full paragraph, which begins with also in April of 2022.
Yeah, so with the April 14th meeting, the students' concerns were listened to and responded to. There was an investigation, and that dealt with meeting with and taking appropriate action with the offending student. I can't remember if some of this is not some information that's available to me. It's confidential when it concerns other students, but I was told that that was dealt with.
Sure.
The April 14th incident.
Right. So it appears there's another meeting that happened in April of 2022. That's the meeting in which the complainant alleges that the principal was dismissive and rude to the student and members of the civil rights team. It appears in that meeting there were additional allegations that students made about the experience they were having within the academic environment at school. Were particular concerns investigated and addressed as well?
Yeah, to me, from reviewing all the information that was provided to me, and like I said, in the issues and resolution conference, we did have 6 witnesses. It did sound like each of and also one of the witnesses did supply me with a 20-page witness statement. So it did seem like all the infractions and incidents that were named were dealt with, either by taking disciplinary action against the student or other remedial action, or taking measures to increase awareness on a larger level within the school community by implementing trainings and other positive programs.
Just curious, I want to clarify something that the complainant said during her presentation this morning. She noted that there was an additional concern, for example, an incident where allegedly a student forcibly removed pride display or flag.
Yeah.
Student's person. I don't see that in this report, but I may be missing it. Can you comment on that particular allegation?
Yes, on June 3rd, the assistant principal received the report of the pride flag pin being ripped off a student. There was an investigation, and there was disciplinary action taken against the offending student. And the school district reported in their June 14th submission to me that there had been no other allegations of removal of pride flags or something similar after that incident.
Yeah, I'm curious about the legal standard here. So, you know, what I've heard today, and certainly in reading these materials, is that there were at least 3 incidents, right, that were substantiated by the school and addressed by the school in some form of either disciplinary or remedial action. So what I'm wondering is that even though, right, in each of those 3 cases, the circumstances were investigated and addressed, doesn't the fact that those circumstances continue to happen suggest that the school district's response, right, is ineffective, right? It's not having, notwithstanding disciplinary, corrective, remedial action, retraining and re-education for students involved in those incidents, as well as the teachers, right, in the school and the school board. Isn't the fact that those issues continue to happen, isn't that evidence that the school district's efforts to remediate are ineffective?
I don't necessarily think that that is the case. So for the March 23rd incident with the inappropriate and discriminatory word being made by a student, there was an investigation, and that student received pretty severe disciplinary measures. So I do think that the school, you know, did deal with these, you know, issues to the extent that they are able to. I don't think that this met the standard of the school being liable for discrimination. I do think the school did respond to the incidents that were cited, both by taking disciplinary measures where it was appropriate, also, you know, counseling the students where it was appropriate, and then also taking these larger initiatives within the school community. So, you know, I think that this was frankly quite the task in for the school to take on, but I do think that they did do, you know, I think they did make a very good effort, and I think that there has been positive changes, and there should be positive changes based on the initiatives that they've implemented.
I asked 2 sort of, you know, new question. The meeting that the student had with the principal, it appears in April of 2022. There's an allegation here that the principal made a comment, quote, boys will be boys. Did you make a specific finding about whether in fact the principal made that comment in the context of that meeting?
The administrator denied making that statement.
Further questions for the investigator? Seeing none, thank you, Angela.
Mm-hmm.
We've heard from the parties and the investigator, and now we will be looking for a motion. There are 2 proposed findings. O'Brien.
Oh, I recommend, I make the motion that there are taken together no reasonable grounds to believe that the school district discriminated against and her minor child on the basis of sex and/or sexual orientation, or gender identity, and I'd like to speak to that one again. Now?
Why don't you finish your motion and then when we get to discussion?
Yes.
Second,
Right, so it's been
Second.
moved and, yes, yep, got you. Moved and seconded, any discussion?
Yes, I believe in this whole, reading this whole thing and hearing the presentation. I think that the parents have been incredibly courageous. I can speak from experience that when a child is hurting in some way, suicidal, whatever, the parent hurts 10 times worse and longer. So I sense the passion, and I really feel for you on that. I do believe, though, that the school district with the trainings and with the committees, and I do believe that they are taking action. And most of that action is probably as a result of you. If that is any solace, I just don't think that there is a connection. I don't think that they, I just don't think that the school district has ignored that. I think they've done all that they can do and continue to do, so.
Any other discussion?
That's all I'm not.
Okay.
I think certainly, apropos Julie's comment, on behalf of parents, I'm a parent too, of a child in a high school, and I want to thank you for your courage in pursuing this matter, and really being very involved with the school community over the past number of years, which is apparent to me. This case is troubling to me. I'm troubled by the fact that, notwithstanding the school's efforts, these circumstances continue to happen, and students who are perceived as different continue to experience these challenges in the school district. So I'm concerned about that. I'm troubled by it, just as you folks are. My hope is that, as Julie noted, and as Attorney Floodley represented to us here today, that there are significant positive developments that have happened as a result of these circumstances. And my hope is that no student ever has to experience this in the course of accessing public education here in the state. So,
Mr. David and then Commissioner Walker.
Yes, it is a troubling case. We're dealing with issues that are will need to be fought out and brought to the attention in all kinds of different environments. In order to find discrimination against this particular individual, I look for whether or not there are policies. I look for whether or not they're trying. And I hear, on balance, the investigator did not minimize the seriousness of the conduct or the harm to the individual, but the investigator also did not find that there were no policies in place, that there was ignoring of the complaints, that they weren't trying. And I don't think the fact that there is work to be done, and Lord knows there certainly is work to be done, both in the school, in individual school systems and in the culture, that doesn't mean that they violated their own policies, or they ignored, or they discriminated against these individuals. Thank you.
Walker?
Thank you. I guess I agree with some of the point of the questions, like Commissioner Sanders. And I take it a little bit further. I think there is a showing to some extent of implicit bias, and could conclude easily that there was a hostile environment. And if I understand the dates and the timing correctly, it lasted from the end of one school year and went into the beginning of the fall of the second school year. If there continued to be a hostile environment, then they did too little too late, and I cannot support your motion.
Any further discussion?
I have a question about the legal standard, and maybe that's for Barbara. I'm curious here in the investigator's report, Investigator Morse lays out the standard, which is, quote, to establish liability on the part of the school for a hostile environment, the complainant must demonstrate that respondents knew or should have known of the harassment and failed to implement prompt and appropriate action. I guess my question is, does that standard apply on a sort of an incident by incident basis? So for example, you know, as we see in the report, as Attorney Plumley notes, each particular matter, school investigated and implemented, in some cases, significant, right, disciplinary action for the students involved. I guess I'm wondering, right, if those actions in isolation don't address the pattern, right, the incidents continue to happen. Talk to me about how the legal standard applies in that context.
Sure, and part of this depends on whether you find that the school knew or should have known about the ongoing environment as opposed to individual incidents to which it did respond promptly and appropriately. So the question is really about what they knew. If they responded promptly and appropriately to all of the incidents of which they were aware, that's one thing. If you find that there were other incidents that they knew or should have known about, then you look at the whole environment, because then they're responsible for that as well.
So with respect to the legal standard, then I heard about 3 particular incidents, right, that were reported and investigated. Based upon those incidents, can you comment on the legal standard about whether the school district then had an obligation, right? So that put them on notice. 3 is a pattern, maybe. Did they have an obligation to conduct, you know, affirmatively conduct a more extensive investigation about what was this student's experience in the academic setting? Can you comment on that?
I can try. There is no settled answer to that question. I will say that part of what an appropriate response is would hinge on, again, whether what they knew and should have known. And the issue of a pattern is complicated in a school environment where there are hundreds of kids, and whether it's a pattern or in one incident at a time, conducted by different kids. The question is whether the district knew enough to say it was a pattern if what was being reported was random different kids. And absolutely at some point they knew or should have known that this was a general atmosphere.
Further discussion.
Can I, at this point, ask a follow-up question of Attorney Family?
Yes.
Sorry, Attorney Family, not at this point.
Nice try.
Thank you for your willingness, but procedurally, that's not permitted.
Okay, thanks.
Any further discussion? Seeing none, motion is to find no reasonable grounds on both recommended findings. If you vote yes, you are in agreement with that motion. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
No.
Commissioner Sanders?
No.
Well, and when there is a tie, the default is to the investigator's recommended findings. So findings are no reasonable grounds. We thank everybody for their participation, and we will send we will send a letter to the parties and the council confirming the results of the hearing. Commissioner David, could we take 5 minutes, please?
Okay. We'll be in recess for 5 minutes only. All set, Chris? Kit? You're on mute. We ready, Chris? Pitt?
Oh, we're waiting for Julie. Sorry, Ed, I didn't realize I was muted.
Oh, I'm sorry. I didn't
Yeah,
see
no,
that
you
she
can
was
hear
not there.
me?
Yes, now I can hear you. Yep.
Okay, great. Once Julie comes back, we'll be ready. Not as cold as it is.
Yes, yeah. I have gone down for a blanket in the past in this room, so.
Okay, Ed, I think we're ready.
Okay, we'll call the last case on the hearing agenda, and it is E220358, Carrie Horrigan versus Weston Hotel. It's a recommendation for no reasonable grounds on both counts. Therefore, we'll hear from complainant.
Good morning. If it's acceptable, thank you, Commission, first for hearing me. If it's acceptable to just be on audio, I'm home alone with 3 kids, one of whom will need toilet assistance. So if I could not have them on camera, I would appreciate that consideration.
That's fine.
Thank you so much. I'm sorry. You guys might hear a little bit of that. To start, as advised in my notification letter, I would like to notify the Commission, please, that I do wish to exercise my right to address comments from the respondent or their counsel.
Would you like to reserve some time to do that then?
Yes, please. Thank you very much.
How much time would you like to save?
I think probably at least 3 minutes. I think what I have to say to you is fairly concise.
Okay, I'll start you off with 7 minutes then, whenever you're ready.
Thank you very much. Okay. I've submitted for your review my written statement of disagreement to the investigator's report from the respectable Mr. Beauchesne. Within, I've listed my objections, in particular to the conclusion. My primary contention is simply the deficit of the investigation and the grounds for the recommendation to dismiss. I'm actually asking the Commission to just consider possibly providing a reinvestigation, not necessarily a right to sue letter at this moment. At the time of filing the initial complaint, I was seeking an impartial investigation as opposed to a lawsuit or going public, and a thorough investigation, as I trust implicitly the MHRC. Unfortunately, I do not feel that my case was fully or properly investigated based on both the chronology and timeframe of the investigation, the changes in investigators, the changes in the respondents' counsel and law firm and numerous attorneys, changes in the management of the respondent hotel. One of the key persons in my case chose not to respond to any of this and chose not to participate. And he was my direct supervisor. None of my witnesses were contacted at any point, despite all of them being present at the incidences that the respondent is claiming. As well as we only had one investigative meeting, which just outlined the differences between my story and the respondent's story, and nothing was followed up on or I think investigated. So I'm just really asking to consider a reinvestigation if the council would please consider. That's it.
We'll have about 8 minutes left when we come back to you. Any questions for Ms. Horgan? Okay. Seeing none, like I did that backwards. You'll have 8 minutes when we come back to you. Attorney Parsons.
Yes, can you hear me?
I can hear you, yep.
I have no idea. My computer just reset and now my video is off. So I was trying to find it.
Okay.
But in order not to delay, I can speak without the video because I don't know how long it's going to take me because it's not showing up as an option.
Okay.
My name is Amy Parsons. I represent Interstate Management Company doing business as the West End Hotel. Just as a point of clarification, counsel for respondent has not changed. I work for the law firm of Ogletree Deacons, and I work with colleagues throughout the firm who participated in writing the response to the commission and also facilitating the interviews and the IRC process. We believe that the findings of no probable cause should be upheld. There was abundant evidence that upon being hired, Ms. Horgan experienced some performance deficiencies. She was hired on August 15th, 2022. It was very clear that her primary responsibility as the beverage director was going to be overseeing the Westin Portland's bar, which is called Top of the East. Top of the East was scheduled for its grand opening, which was a significant event. As it became closer to the grand opening time, really just 2 days before the grand opening, Ms. Horgan expressed concerns that her car broken down and she wasn't going to be able to come into work. As you might imagine, the beverage director's position is fairly critical in terms of overseeing and facilitating the grand opening of this new bar on top of the hotel. The Westin did everything in its power to work with her, including obtaining a rental car on the personal credit card of the hotel's general manager, Mr. Carl Whipple.
Attorney Parsons, please don't use the names of third parties.
I'm sorry. Her general manager. The hotel paid for, the rental car in order to get her to the site so that she could work with her staff in the grand opening for the Top of the East bar. The rental fell through overnight. They had to work on a new rental. As the investigator's statement reflects, on Thursday, September 1st, the day prior to the grand opening, the hotel's human resources manager personally picked up Ms. Horgan and her the HR director. Is there a problem?
No, you're back now. You cut out for just a second.
I'm sorry. I'm in my office. The HR director picked up Ms. Horgan and her son and delivered Ms. Horgan's son to daycare on the way to bring Ms. Horgan to work and to get the rental car. As set forth in the investigator's report, there were several concerns about Ms. Horgan's performance on this big day of the grand opening. There were some issues with Ms. Horgan and the restaurant manager having some disagreements. Human Resources investigated that and determined that Ms. Horgan, for whatever reason, believed that the restaurant director should be reporting to her, which was not actually the case. So the hotel talked with both of them and both were instructed, to act professionally moving forward, which they did. On the day of the grand opening, which was Friday, September 2nd, Ms. Horgan showed up 45 minutes late for her 11 a.m. meeting. Again, the hotel discussed with her the organizational structure, the fact that the restaurant manager did not report to her. It was a huge concern for the staff that instead of working on the preparation for this grand opening, on the day of the grand opening, Ms. Horrigan was instead meeting with a wine rep in the hotel bar. There were concerns again expressed by hotel staff, including management staff, that Ms. Horrigan was having problems again with the restaurant manager. At 4:30 on the evening of the grand opening, which was scheduled for 5 p.m., it was brought to the hotel's attention that Ms. Horrigan had not set up the point of sale system to program in the menu, which meant that the staff was going to be doing open tickets on food and beverages all night, which was incredibly difficult and time consuming and should not have been the case. At 4:30 p.m., just a half hour prior to the grand opening, Ms. Horrigan was still finalizing cocktail recipes with the staff. This is something that should have happened a week, 2 weeks prior to the grand opening, not 30 minutes prior to the opening. There were concerns expressed by other management employees that Ms. Horrigan may have been under the influence because they noticed the odor of wine on her breath. Human Resources met with her, and while she didn't notice the scent of wine or anything on her breath, she did have a discussion with Ms. Horrigan about the fact that her staff was very concerned and alarmed. People felt disorganized. There weren't enough staff members even to staff the event. They were still finalizing their menus just a half hour and 15 minutes before service. And so after this conversation with Human Resources, the Human Resources Director could tell that Ms. Horrigan was not feeling great. Human Resources Director gave an opportunity to go home and collect herself or to stay and lead the service. Ms. Horrigan wanted to stay for the opening. Additional issues came up after the grand opening began. The bar back contacted the chef to say that none of the wines were stocked in the bar for this grand opening event. And as the chef and the restaurant staff worked to bring the wine up, which was not their job, it was reported that Ms. Horrigan was having a meltdown and was very upset and crying and talking about her conversation with Human Resources with an hourly associate and a manager from another team. Ms. Horrigan left the property, and on the next day, because there was so much concern about Ms. Horrigan's performance at this very peak event, an event which she had been supposedly preparing for 2 weeks, she was asked not to come in on the following day so that Human Resources and management could discuss how they wanted to respond to the performance. It was that day that the general manager and the chef went to Ms. Horrigan's office and observed from outside of the office several open wine bottles. There were open champagne bottles in her mini fridge. And as explained in the investigative report, Ms. Horrigan was unable to give a clear response as to why those open wine bottles and champagne bottles were in her office. It was entirely inappropriate. Under no circumstances should a beverage director have had one wine bottle opened in her office, much less several. We believe the investigator's report got it right in determining that Ms. Horrigan is unable to establish her claims of sex discrimination, age discrimination, discrimination on the basis of family status, or retaliation. In terms of her sex discrimination, respondent denies that Ms. Horrigan was able to establish that she can perform her job satisfactorily. She did not perform her job satisfactorily. She was hired, she had 2 weeks to prepare for an event, and everything that could have gone wrong essentially went wrong, not because of, things outside of her control, but because of a lack of preparation. It just seemed that she was in over her head. The investigator found that respondent provided a legitimate and non-discriminatory business reason for terminating Ms. Horrigan's employment, and it was based on her failure to perform at that event, and also the concerns about violations of its drug and its alcohol policy. Prior to making the decision to terminate Ms. Horrigan's employment, Respondent provided her with an opportunity to provide a statement and explain why things had gone the way that they had and why she had these bottles open in her office. And Ms. Horrigan declined to provide a statement, which is what sufficiently led to her termination. She did not want to participate in the investigation and provide information as to why her performance was lacking in the way that it was. Additionally, Ms. Horrigan claims that she was discriminated against on the basis of familial status and being a single mother. She alleges that the discrimination was based on sex. She alleges that the discrimination was based on age. However, the hotel's general manager, who was in fact responsible for hiring Ms. Horrigan, is the same person who made the ultimate decision to terminate her employment. Ms. Horrigan revealed unsolicited at her interview process that she was a single mother. She talked about it at length. This was unsolicited.
Parsons,
Yes.
that's your time.
Okay, thank you. I'm happy to answer any questions, and I'm still trying to get my screen on.
Any commissioner questions for Attorney Parsons? Commissioner Sanders.
Just one, the written policy that prohibits consuming alcoholic beverages while at work, how is that policy communicated to the complainant?
At the inception of complainant's employment, she underwent training on August 15th. She was trained on all of the policies and procedures with the hotel's human resources team. And that was one of the policies and procedures that she was trained on at the inception of her employment on August 15th.
Your video is
You're
on.
back.
Oh, I changed the camera. I was not stressed out and I was able to change the camera. I can't do it while I'm supposed to be speaking.
Any other questions for Attorney Parsons? Okay, seeing none, we'll go back to you, Ms. Horgan. You have about 8 minutes left.
Thank you. The attorney addressed all of the reasons why they felt justified in terminating me, but didn't spend any time really addressing my actual complaints. And my request to have this reinvestigated is that there are a number of staff members, including members of my team, including members of other management positions who were present for all of these things that they are accusing me of, who can actually negate, because they were eyewitnesses, working as my colleagues, working as my subordinates, who negate everything that's being said right now. I also find it very curious that the person who I directly reported to, the GM, is not participating in this. It was not addressed. The number of conversations that I had, where I was interrogated regarding my single motherhood, whether I could handle this or not, that happened prior to any of their complaints about my performance. Their complaints about my performance only happened after I reported this person that we're now calling, I guess, the restaurant director, who did not have such a title at the same time. I regularly sent her home for her being intoxicated on the job, as per company policy. None of this has been addressed at all. And I had a number of witnesses who were never contacted who can testify that that's what happened. I regularly complained about that. So we're going over complaints that happened after my termination, now discussing my job performance, which don't really have anything to do with my complaint. But I have a number of witnesses who can say the exact opposite, and none of them were contacted. One of my witnesses provided a notarized affidavit, and he was never contacted. And he even emailed the investigator himself to say, I would like to participate, please. And he was never responded to in 2 years' time. So that's why I'm just asking for this to be reopened. I don't agree with all of these claims. And like I said, there are witnesses plenty of, who can say that this was not their experience working with me. And I feel like this is a little bit of a retaliation for my filing this complaint. And I did reach out to this particular law firm to say, I would like to resolve this quietly and all of us move forward, because I don't want this to go to a lawsuit. And I was never contacted regarding that. So I would like this to be reinvestigated. I'm not sure why somebody who participated in conversations regarding my single motherhood and my sex was never questioned by the investigator, and why he's not participating. And like I said, the number of witnesses that were a party to all of these instances that now the Westin is bringing up, I'm not sure why they were never contacted. And then the person who benefited the most from these accusations is the person who made these accusations and subsequently took my place. So that feels a little potentially nefarious in intention. That person benefited and profited from these accusations. The person who made the accusations took my position. So that's, I would just like another investigation, a second look at all of this, please. Thank you. That's it.
Any questions for Ms. Horgan? Seeing none, we've heard from the parties. Unfortunately, Investigator Beauchesne got stuck in Texas on the way back from vacation. So he is unable, I believe he is on a plane right now, so he is unable to present, but our lead investigator, Jane O'Reilly, has reviewed the file and is here to present and answer any commissioner questions. Barbara has also reviewed the file, so back up.
Yes, good morning, everyone. As Kit mentioned, I'm here presenting on behalf of Investigator Beauchesne. I have reviewed the entire record as well as the investigator's report and the submission of disagreement. I don't have much to add in terms of facts for this case based on the presentations that were just given. I'll basically say that this is sort of a case of there may be a dispute as to the reasons behind the discharge. You know, complainant may dispute that the allegations made against her that formed the basis for her discharge were true, but has failed to provide any evidence that the true reason is discriminatory. So there may be a dispute. We obviously, weren't there, didn't make the decision on behalf of respondent, but complainant failed to provide any evidence that the true reason was discriminatory, even if respondent was incorrect about some of the performance deficiencies or any other accusations that were made. I'm happy to address any other questions. And again, Barbara Hirsch is here too. Barbara Archer Hirsch, sorry, I missed one of your names, is here to assist me with the record.
Any commissioner questions for Jane or Barbara about the record in this case? Okay, thank you, Jane. We've heard from the parties, we've heard from the investigator. At this time, we'll be looking for a motion. There are two proposed findings.
Move to adopt the recommendation laid out in the report as written with respect to no reasonable grounds to conclude that the hotel discriminated against the complainant on the basis of sex, age, disability, familial status, and or for being a recipient of a protection order, or that the hotel retaliated against the complainant for engaging in WPA and or MHRA protected conduct.
Second.
All right, it's been moved and seconded. Any discussion? None. Motion is to find no reasonable grounds on both findings. Jane just sent me a message. I just want to make sure I hadn't missed anything. So the motion is to find no reasonable grounds on both findings. If you vote yes, you are in agreement with that motion. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Okay, so the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Commissioner David.
Thank you.
Pursuant to 1 MRSA section 4056E, I move to go into executive session to consult with our attorney pending to discuss pending and contemplated litigation and the legal rights and duties of the commission.
Seconded. Any discussion? None. If you vote yes, you are in favor. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Okay, we will be in executive session. Ed, I will figure out how to put you in a breakout room.
Okay.
So let me go back. Now it's gonna get complicated.
No, if I find the MHRC meeting, still. Will you mute us, Chelsea, and turn off the camera? You might know it's something. It might
I know, you'll be the thing. My eyes haven't worked in months, sorry, I forget all about them.
There we go.
Okay. All right, Ed, can you hear us?
Yes, I can.
Okay, so we need a motion to litigate H 23-0374 and not to litigate PA 22-0305. So, Julie, your second. Okay, so the motion is to litigate H 23-0374 and not litigate PA 22-0305. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Great. That concludes our business.
Good.
Great. All right.
So bringing back the important subject of.
Hang on a second, let me get
donut.
Go ahead.
the donuts. Oh, okay, all right. Thank you, Ed. Enjoy the rest of your time.
Thank you.
Will you be here on Zoom in August as well?
No, actually, I have some other business, so I'm going to come home and be at the August meeting, and then I'm coming back. I probably won't be at the September meeting
Okay.
because I'll be back up here.
Okay, great. Thank you very much.
See you then.
See you.
Thank you.
The Foley's that we're talking about
Yes.
is closed.